DC 2/2022/2024 in the matter between Paseka France Botswaneng, the first applicant, the second applicant being Vincent Kemelat Baloy, the third applicant being Revival Motswaneng. This is the state. There is a bail application brought by the applicant before this court. It is imperative to note that this bail application was on the roll of District Court number 2 next door, and due to last-minute logistical and heavy court roll of District Court number 2, the matter was placed before this court. The application commenced at about 2 p.m. on Friday, the 16th of August 2024, and the court noted the displeasure of the defense that the state was deliberately delaying the said matter. Mr. Vilakazi is appearing on behalf of the state, and the counsel for the three applicants is Advocate Lamini. The state is opposing the bail and that it is a Schedule 5 bail application. It is common cause that the applicants before this court are charged with 12 counts of various offendings ranging from kidnapping of minors, 2 counts of assault by threat, 1 count of assault, possession of prohibited firearm, 3 counts of discharging of a firearm in a built-up area or any public place, 2 counts of pointing of anything likely to lead a person to believe it is a firearm, 1 count of malicious injury to property, and 1 count of possession of dangerous weapon. The various offences were allegedly committed on the 5th of August 2024 within the court's jurisdiction. Now, it is tried law that the applicants are entitled to be released on bail if the court is satisfied that the interests of justice permit their release as envisaged in Section 60, Subsection 11B of the Criminal Procedure Act. This section informs us that the court shall detain the accused until they are dealt with according to the law, unless the accused adduces evidence which satisfies the court that the interests of justice permit their release. The applicants submitted the affidavits in support of their bail application. In the affidavit, they detail their personal circumstances and confirm that they intend to plead not guilty to the charges. The applicants' affidavit were confirmed and signed by them, and they were handed in and marked Exhibit A, B, and C, respectively. Applicant's number one's personal circumstances was read onto the record. He states that he is a pastor at Incredible Happenings as well as director of Incredible Happenings Trading CC. He does not have any previous convictions and or any pending cases or any domestic violence order or harassment orders against him. He stipulates that he is deeply rooted in the Katlehong region and he has children. One of the children of the accused number one is accused number 3 in this matter.
Protection order, harassment order,
He further in his affidavit states that he has employed 30 people from whom depend on him for their living. As a result of his continued detention in custody, he will severely prejudice the said employees. Further to that, he informs the court that he financially contributes to the upkeep of his grandchildren, as the church which he is a pastor of has employed applicant number 3, and as a result of his detention, the best interest of the children will be affected. He can afford bail of 3,000 rands. Applicant's 2 personal circumstances were also read onto the record. He is the bodyguard of the first applicant. He has no previous convictions, has no pending cases. He has no domestic violence orders, protection orders against him, no harassment orders against him. He states that if he fails to provide services to applicant number 1 as a result of his detention, his employment will be terminated. He can afford bail of 500 rands. Applicant's 3 personal circumstances was also read into the record. What the court can gather from this affidavit is that he is the father of the 2 minor children who are referred to in count 1 of the kidnapping charge. He has no previous convictions, no pending cases. He has no domestic violence order, protection orders against him, or harassment orders against him. He submits to the court that his 3 minor children need him as they depend on him. He informs the court that he is a widower and his continued detention will not be in the best interest of the minor children. He can afford 500 rand bail. In all the affidavits, they stated that they addressed all the provisions and or factors that are listed under Section 60, Subsection 4 to 9 of the Criminal Procedure Act. That was the applicant's case, and they closed their case. Now, the respondent provided a long bail application affidavit. It was deposed by the investigating officer. It was read onto the record. I will not repeat same, but only provide a brief summary of the day of the incident. The captain states that in addition to the above mentioned offenses, There is also a charge of trespassing and contravening Section 21A of the Private Security Industry Regulation Act 56 of 2001. According to the investigating officer's affidavit, there seemed to be an incident that transpired on the 1st of August 2024 before the main incident being the 5th of August 2024. The investigating officer submits as follows from paragraphs 8 to 9 of the said affidavit that there were accused number 3 had taken 3 minor children from the school without informing anyone, and this necessitated assistance of the police, who attended to the property of accused number 3 and 1 and then the property of accused number 1, which they were not found. Now, on the 5th of August 2024, one of the witnesses who is employed at the school where the minor children of accused number 3 attend and where the said alleged offences transpired, found the said minor children in their respective classes. The said minor children informed the witness that their father, accused number 3, accompanied them to school. When school times had concluded, accused number 3 went to collect his children, and this is when the scuffle and chaos erupted at the said school. It is stated in the affidavit that the deputy principal attempted to contain and resolve the said impasse, but was unsuccessful, and an unpleasant scene therefore erupted and or started. The witness observed that accused number 1 had 2 pangas, or machetes if you can say, which he used to intimidate and threaten individuals who were on the scene. Accused number 3 was pleading with the deputy principal to release his children into his care. It was at this point, as the witness describes, that accused number 1 gave accused number 3 one of the pangas, and he forcefully opened the burglar gate and removed his children and left the school premises. Accused number 2 is described as the individual who was carrying a firearm described as a rifle. The investigating officer submit that a witness was pointed with a firearm described as a pistol by accused number 1 as they were exiting the school premises. This was when it was observed that accused number 1 was instructing one of the witnesses not to record the said incident. They entered into the vehicle of accused number 1 and drove away. The witness also states that they heard gunshots before all 3 accused drove off. The investigating officer states that the maternal grandmother of the two minor children did arrive at the school premises upon her other daughter, who went to collect the minor children, informed her that accused three had taken the children forcefully. She is one of the witnesses who claimed that she was assaulted by accused number one. The investigating officer further stated that after the first court appearance, which was the 6th of August, he went to view the video footage where he observed the said vehicle of accused number one and him discharging a firearm in public, and the said firearm is not the same as the same firearm that was in the possession of accused number two when the incident happened. Paragraph 10 of the investigating officer's affidavit is key-worthy to note that it offers explanations of the accused's physical addresses, which will be expanded upon below. The investigating officers then individually provided information about the respective applicants before court. This is their personal circumstances, their criminal history, etc. And applicant number one, the investigating officer is opposing bail on the basis that the applicant's residential address is negative and that there's no number 2027 Gumete Street in Albemarle. Therefore, accused number one offered an incorrect address, which will thus be impossible to trace. The other view that the investigating officer holds is that the accused number one is concealing other firearms that have not been recovered by the police, and as such, this poses a danger to the witnesses and the community. The investigating officer states that accused number one does not have any previous conviction or pending cases. However, in his profile, he has 9 cases that were withdrawn. He tells the court that accused number one was the instigator of this incident and is a danger to society, more so to the witnesses and the maternal grandparents. He further opposes bail in that this incident was widely publicized on all social media platforms and has shocked the community. He further submits that the accused are in danger, as accused number one is a prominent pastor, and subsequently of this incident, his church was set on fire and burned down as a result of the community being angry and unimpressed with the conduct of accused number one. Applicant number 2, the investigating officer is opposing bail because his address has been verified and he resides alone in Boksburg and he can evade his trial. He further submits that he's a danger to society as he does not possess any licenses for the firearm he had in his possession and that he can easily access unlicensed firearms. Applicant number 3, the investigating officer is opposing his bail in that he provided incorrect address, therefore he has no fixed address. That was the respondent case and no further evidence was presented. The investigating officer's affidavit was handed in and marked Exhibit E. Now, in deciding whether applicants are candidates to be admitted to bail, the court needs to clarify certain issues. Whether the applicant has discharged the owners under Section 60, subsection 11B of the Criminal Procedure Act. Another aspect is that the court has to consider is whether the applicant successfully passes the factors listed under Section 60, subsection 4A to E, as well as Section 60, 5 to 9 of the Criminal Procedure Act. Now, the court would like to make it clear that it is not the duty of this court to determine the guilt of the applicants before this court. That's for the trial court to determine. What is of importance is that it's for the court to weigh up the evidence before it and provide a value judgment whether on a balance of probabilities have the applicant before this court successfully discharged the required owners placed on them. Now, the right of an accused to apply for bail, it is found in our Constitution, Section 12 and Section 35 for 1, D, E, F. They expressly protect this right to apply for bail. In the case of S versus Japal, it states that the right of an applicant to apply for bail and the urgency thereof is important, but equally important are the rights of the public and the complainant as well.
S versus Japal, which is
the court has to look at the factors listed in subsection 60, subsection 4A to E of the Criminal Procedure Act, but not in isolation, as these factors must also be read in conjunction with Section 60, subsection 5 to 9. These are factors to determine whether indeed the applicants are or do qualify to be admitted to bail. The court is also mindful that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. The court will quote, I see Mr. Dlamini quoted it from S versus Diale. The court will quote the same quote from S versus Swanepoel, which says that a court cannot find that the refusal of bail is in the interest of justice merely if there is a risk of or possibility that one or more of the consequences mentioned in subsection 4 will result. The court cannot grope into the dark and speculate. A finding on the probabilities must be made unless it can be found that one or more of the consequences will probably occur. I turn now to look at the facts presented. The applicant before this court submitted affidavits in support of the release on bail. The court must disappointingly note that all three affidavits was a cut and paste of one of the other with only varying differences, as the respective personal circumstances can never be the same. I must also note that the said affidavits were littered with unnecessary spelling errors. There was not much great care and skill taken when the said affidavits were drafted. Case in point, the said surnames of applicant 1 and 3 are different to that of the surnames on the charge sheet. Now, there is a clear copy and paste of the criminal procedure sections, which the applicants must elaborate and discuss in order to show that they are candidates suitable for the release on bail, but they fail to do so. The investigating officer gave a detailed and comprehensive bail affidavit. In the affidavit, the court was given a clear picture of what transpired on the day of the incident. It is also tried law that hearsay evidence is admissible in bail proceedings, and that bail process is sui generis in nature. Basically, anything goes in a bail application because of its uniqueness. Now the court has to weigh up all the factors and decide on a balance of probabilities to determine whether applicants can be admitted to bail. The case of S versus Shititak encapsulates this reasoning clearly, which basically states that bail proceedings are sui generis in nature. The state does not oblige in its turn to produce evidence in its true sense. It is not bound by the same formality. The court may take into account whatever information is placed before it in order to form what is essentially an opinion or value judgment of what an uncertain future holds. It must be prognostic to do this. It must necessarily have regard to whatever is put by the state in order to decide whether the accused has discharged the onus placed on them. Now let's look at applicant's number 1, affidavit. It is common cause that he is a prominent pastor and his church is very well known. It was also not disputed that the said incident was publicized on national television and on social media. Applicant number 1 simply gives the court nothing other than to place his circumstances on record. He does not thoroughly explain the impact of his incarceration. He only informs the court that he is responsible for 30 employees and that his church members will suffer spiritually if he is not released. He does tell this court that his mother will suffer as he financially provides for her needs and medical needs. He does not explain how he was arrested, nor explain the charges that he faces. I touch on the manner of how he was arrested because the investigating officer in his affidavit submits that the J50 warrant was executed in order to arrest applicant number 1. It is common knowledge that a J50 warrant is applied for when a suspect is wanted and cannot be located at their respective residential address. This, the court believes, is also one of the important aspects that applicant number 1 should have thoroughly ventilated in his affidavit. He does not explain that this incident was recorded and therefore causing a social media frenzy. He does not explain that on the day of his bail application having commenced, which was the 16th of August 2024, his church was burned down to ashes, as the investigating officer informed the court. Applicant number 1 simply gives no effort in addressing the factors which would enable him to successfully discharge the onus placed on him. The court disagrees with the investigating officer that applicants 1 and 3 do not have fixed addresses. It is unbelievable that an individual of the stature of being applicant number 1 that he possesses will not have a fixed address. It is clear that the address on the said charge sheet was incorrectly spelled. Applicant number 1 and 3 provided an address by submitting a rates and taxes account from the municipality, which was handed in and marked Exhibit D. I do agree with Mr. Vilagazi when he says that the two addresses were combined, because 2072 Gumeta Street is in Katlehong, and then the address that's provided by the applicants before this court, the one in Geffen Avenue, is in Albemarle. So it's clear that the said address was combined. Therefore, that's why the investigating officer could not locate it in Albemarle. Furthermore, it is a submission of the investigating officers that the police officers, they went to applicant's number 1 residential address on the 1st of August, 4 days preceding the main incident. So that surely confirms that the address is indeed positive and was verified. Mr. Vilagazi made submission that the previous cases of applicant number 1, he gave different addresses. This cannot be a basis to state that he does not have a fixed address. Even for applicant number 2, the investigating officer cannot come and tell this court that just because applicant number 2 resides alone, he is a flight risk and can evade his trial. His address has been verified, therefore the court holds no issue with the addresses of applicants number 1, 2, and 3. Applicant number 2's affidavit also provides this court with nothing. Personal circumstances are on record, and that is as far as the affidavit goes. He neglects to fully canvass the provisions that are of importance in determining whether a candidate is suitable to be admitted to bail under Schedule 5 offense. Applicant number 2 fails to address the issue of him being a good bodyguard and whether he is registered by the applicable authorities to become one. He does not dispute that he holds no firearm license, and he does not dispute that he was on the scene of the incident. All he gives to the court is that he intends to plead not guilty. The investigating officer also submitted that applicant number 2 was brandishing a firearm which was described by the witnesses as a rifle. The court cannot ignore this point. I now turn to applicant number 3. Now, inasmuch as applicant number 3 gave a sloppy affidavit which does not tell this court much, case in point, he says he is a widower but does not provide proof to this effect. The investigating officer's affidavit comes to his aid and assists applicant number 3. The investigating officer gives a background of why the said incident transpired. The investigating officer also does not mention much apart from him opposing bail against applicant number 3 in that his address is negative. I have concluded above that the court takes no issue with the addresses that they have been verified. Now, Advocate Lamini, counsel for applicant number 3, correctly points out that applicant number 3 does have parental rights and responsibilities as protected in Section 21 of the Children's Act. There is no court order before this court that states otherwise. The 2 minor children have only one parent, and that is applicant number 3. To deny the applicant number 3's right to take care of his minor children will be an injustice to the end. This court will not go down that route. Now the investigating officer provides a picture to the court of what exactly happened on the day of the incident. What is also worth noting is that the investigating officer suggests that it would be beneficial for the accused to be kept in custody as a measure to protect the applicants before this court. The affidavit is clear that there is an outcry and displeasure of the accused's conduct. To have a prominent pastor commit such a heinous act in the presence of minors, which he ought to have protected as he is their grandfather, has left the community angered. So much so, as the investigating officer stated in that the church, the applicant's number 1's church, has been burned to ashes. This is indicative of the anger of the community. Perhaps they could as well be paying for his blood. The affidavit of the investigating officer also shows that there are too many witnesses who were subjected to this ordeal, and what could also not lose sight of the fact that this incident occurred in a public school where minor children are enrolled at such school. The conduct of the applicant may as well have left the witnesses and learners traumatized. Now, Section 28, subsection 2 of the Constitution tells us that the fundamental point that the best interests of the child are of paramount importance, and as such, it is the duty of this court to protect children and ensure that they are protected in the environment where they receive education. This is not only in respect of the 2 minor children affected by this incident, but by the learners of the said school where this incident transpired. To be brandishing dangerous weapons and firearms in an environment and institute of learning, this the court shuns the behavior of such. Now, in the case of S. vs. Shabalala, it was stated that the court must assess the appellant's future conduct in the light of existing or historical facts and circumstances. I cite this case in support of the factors listed in section 60, subsection 4A to E of the Criminal Procedure Act. This, the court then must balance the right of the accused and those affected by the incident. Did the applicant discharge the onus placed on them? Do they satisfy this court with the evidence that they have placed before this court with their affidavit that they are suitable candidates for bail? Now, the only thing that this court must do is just to make sure that it's satisfied that all 3 applicants before this court, they can attend their bail, their case before this court. This is not the duty of this court to determine the guilt of the accused, as I've said. That's for the trial court to do. Now, it is quite unfortunate that the affidavits presented by the applicants before this court were not satisfactory, and simply they were just not giving of anything. The onus rests on them to demonstrate that they've adduced evidence that which are in the interest of justice to permit their release. The court has considered all angles and dissected the affidavits, and simply there is no indication that the said onus was discharged. This court is a creature of statute, and it does not operate on emotions or influence. It is not a reactionary court, but simply deals with the facts presented before it. It is a creature of statutes and does not have inherent jurisdiction as that of the higher courts. So it simply can only do what is permitted to do within its own legislative framework. If the applicant fails to discharge the onus placed on them, then it is therefore clear then what should follow as a result thereof.
tsamaiso ya toka e dumela jang ka ditokolo ba tseba gore go tla letla ka qeto ya mofuta ofe mo godimo ga kopo ya mothusi.
The applicants did not have an obstacle of discharging the higher burden found in Schedule 6 bail applications. They simply needed to demonstrate to this court that the interest of justice permits their release as opposed to the higher test found under Schedule 6 bail application. Their affidavits do not dispute that they are linked to the offenses preferred by the state. There is a strong case against them. And frankly, they did not put up a fight in ensuring that the evidence submitted by them hold enough water to discharge their owners. Now, I have expressed above that the investigating officer comes to the aid of applicant number 3. It is clear that the investigating officer has no reason why he is opposing the release of applicant number 3, and in the circumstances, the court must do what is fair and just. Applicant number 1, 2, and 3, please stand. Now the court ultimately looks at what is presented before it, and it provides a valid judgment from the said evidence. This court is persuaded that this case consists of so many probative factors which tips the scale in the respondent's favor. Now, in considering all the evidence before this court, the evaluation of the factors listed in Section 60, subsection 4 and 5 to 9 of the Criminal Procedure Act, applicant 1 and 2 have not discharged the owners that rest on them and have not adduced any evidence which has satisfied this court that it is in the interest of justice that they be admitted to bail. Applicant number 3, there is no basis that he should be detained up until the finalization of this matter, and therefore the court shall grant his release from custody. So then the order is as follows. Applicant number 3, you are released on warning with the following conditions. You are to have no direct or indirect contact with the witnesses of this matter, save for the maternal grandmother and aunt under the guidance and assistance of the Children's Court. You are prohibited from entering the said school premises where this incident occurred up until the finalization of this matter. The court is aware that this condition, it will impede you exercising your parental rights and responsibilities, but this is only until the finalization of the matter, alternatively the outcome of the Children's Court matter. You are therefore warned to appear at the Knox Court date, and failure to do so, you may have your release on warning cancelled. and therefore applicant number 1 and 2, your application for bail is hereby denied. Mr. Vilakazi, date? Date.
Your Worship, the court, or rather the state, is begging this court's indulgence, Your Worship, that maybe the state be granted a period of 2 months, Your Worship, for the investigations. Still ballistics outstanding and so forth, Your Worship.
I don't know. Then the date with the defense then. It will be for investigations, correct?
Yes, Your Worship.
The date, Advocate Dlamini?
Mr. Chairman. 2 months.
That is true, though. Your Worship, that's too long.
I don't know.
I understand, Your Worship. However, we're gonna be in the same position, because if we get a shorter remand, we're gonna ask for postponement again for further investigations in any event.
How many?
Your Worship, 2 months. Accused number 1 and 2 in prison. That's completely situation where they are denied.
But the state is saying that they still need to investigate. And I'm sure with ballistic report, we know the situation at our criminal laboratories, that there's a backlog there. So surely that ballistic report is going to take quite some time. Hopefully it will be sped up.
Can I consult?
You may.
Your Worship, we will accept the state proposal, but we need a date, Your Worship.
Yes, you must provide me the date. Look at your diary and let me know.
That is a 2 months.
Date.
Give them a date.
Okay, indulgences. The 21st of October.
What day of the week is it?
Monday.
Is it suitable, Mr. Dlamini?
It's suitable.
Gentlemen, you then appear in District Court number 2. That's the reception court. On the 21st day of October for investigations. Accused number 1 and 2, since your bail has been denied, you shall remain in custody. Accused number 3, you are released on warning with the condition that was set before this court. You are warned for 8:30 District Court number 2. If you don't come to court, a warrant of arrest will be authorized against you. 21 October, DC2, 8:30. I want to advise the gallery the court is still sitting with other matters, so if you're going to leave, please leave quietly. Yes, that's what I wanted to say. The court is still sitting. I've got other matters to proceed with. So if you're going to leave, please leave quietly. Stick it around.